If you're an Indian who's living in the US illegally and you ever thought that you're safe at home, think again. A new internal memo from ICE has revealed that agents are now entering the home of certain immigrants without a judicial warrant. This change raises alarms about due process, civil rights, and how far immigration enforcement can really go. There's the secret memo that has been leaked. That's right, a memo issued on May 12, 2025 by ICE Acting Director Todd Lawrence. This particular memo was never to make public until whistleblowers shared it with Senator Richard. According to that particular memo, once a person has a final removal order, ICE agents can enter their home using an administrative warrant. Administrative warrants do not require a judge's signature, unlike the judicial warrants used previously. This is a major shift in immigration enforcement policy, and it gives ICE agents the power to enter homes forcibly, all in the name of carrying out final deportation order. But let me explain it to you. What is this administrative warrant first of all? Unlike the judicial warrant, administrative warrants are signed internally, not by a judge or any magistrate. ICE now uses Form I-205, a document that identifies the person and state the purpose of arrest. Well, according to DHS, the Constitution and immigration law allow administrative warrants for people who refuse to leave after a removal order. Specifically, it is very important to know that if you have been ordered to leave the US and you stay, ICE can knock at your door anytime and take action. Now, what it means for the immigrants. Previously, ICE needed a judicial warrant to enter somebody's home. Now that legal safeguard has been reduced. Whistleblowers warn that newly recruited agents, that is about 10,000, they may not be properly trained on limits of administrative warrant, which would make enforcement even more aggressive and unpredictable. Well, ICE claims that I-205 is not a research warrant and is only for immigration arrest, but the lines are blurry and experts fear abuse of power. But yes, there is limited distribution of the memo as well. This memo, it was technically circulated to all ICE agents, but in reality, only a few agents received a copy. Well, most of the agents, they were given verbal instructions only, leaving room for confusion and potential overreach. Whistleblowers stress that without proper training, home entries could become more ruthless, specifically for people with final removal orders who are hiding or resisting deportation. And DHS also is defending this particular policy. Their spokesperson, Tricia McLaughlin, well, that person said that those with final removal orders still have due process. The I-205 is issued for a specific purpose to carry out the deportation order. But here critics argue that due process protecting, they are being weakened, leaving immigrants vulnerable in their own homes. So in the end, ICE now has the new power to enter homes without judicial overnight. Administrative warrant and Form I-205, they are being used to enforce deportation aggressively. With massive recruitment underway, whistleblowers fear the agency could become more ruthless than ever. So the question is, how far can ICE go before civil rights are compromised?